Miss Patino. Miss Patino, you are the movant, right? Okay. Take yourself off of mute. I can't hear you.
Oh, yes, I am. I'm sorry, Your Honor.
No problem. All right. So I did not receive any exhibits from either side.
I did my exhibits. It should be 1 through 19, but they were admitted last week.
You sent them to Judge Lee?
Yeah, both sides got them. There was no objections.
Okay, hold on.
I, I,
Oh, I
I'm
see it.
just
It's a zip file.
Correct.
Okay. And is it my understanding that you're just moving forward with the motion itself, no contempt?
Correct.
All right. Hold on. Let me try to. Sometimes the zip files don't work. And I did receive State's Exhibit A.
I got 1 through 19. Is that what she said?
Yes. One,
Yeah.
2, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 17, 18, 19. Okay, I have 19. So 5 is A, B, and C.
Okay.
All right. And Mr. Ramirez, you don't have any exhibits on father's side, is that correct?
No, it's Mr. Samuel.
No, Mr. Samuels was the last person. He just didn't change the name.
no, no. I am Mr. Samuels.
You're Mr. Samuels.
Yeah.
Oh, hold on.
Mis-
The pleadings is Mr. Ramirez.
yes,
Why
yes.
you let me
Mr.
call
Ramirez.
you Mr. Ramirez this whole time?
Well, Mr. Ramirez is the senior partner. It happens all the time. I just kind of let it happen.
You're a good sport. Okay, Mr. Samuels, I have it. Okay, so you didn't provide any exhibits, right?
No, Your Honor.
Okay, all right. So Joey, let me know when you're ready. All right. We're on the record in cause number DF2207329. Councils, will you please announce for the record?
This is Brandon Samuels with the Garcia and Ramirez Law Firm here on behalf of Respondent Mr. Vidal Gallegos.
Thank you.
Joyce Wanchaku for the Office of the Attorney General.
Thank you. And Ms. Patino, would you please remove yourself off of mute and announce for the record?
Kristen Patino, movement, pro se.
All right. And those who intend to testify, would you please raise your right hands? Mr. Samuels, I cannot see your client.
Mr. Gallegos.
Oh, there he is. Mr.
Yeah.
Gallegos, would you remove yourself off of mute?
Yes, ma'am.
Okay. Raise your right hands. Do you both swear or affirm that the testimony you'll give will be the truth and the whole truth?
I do.
Yes.
Thank you. You may lower your hands. Are you all expecting an additional witness on this case? No.
Your Honor.
No.
All right. Okay. So we are set here today on the First Amendment motion to enforce child support and medical support filed by Ms. Patino. The court is aware that Ms. Patino, you are taking contempt off of the table and you're just proceeding with the violations. Is that correct?
Correct.
All right. And prior to going on the record, there were some exhibits that were pre-admitted. They will be admitted at this time. So State's Exhibit A, the pay record is admitted, as well as Miss Patino's exhibits 1, 2, 3, 4, 5A, 5B, 5C, and then 6 through 19 are all admitted. And Mr. Samuels's client did not have any exhibits to tender. Is that correct?
Correct, Your Honor.
All right. And Ms. Patino, you're representing yourself. So I always ask, have you and Mr. Samuels had an opportunity to discuss any settlement in this case?
Yes.
Okay. And not successful on that.
I feel like I took jail off the table, so.
Okay. Let me get you all doing your timer now. Hold on 1 second. So, Ms. Patino, what are you asking for today?
I would like to waive my opening statement and offer my Exhibit 1 as my summary of relief.
Okay,
And
all
I
right.
and I also respectfully ask the court to take judicial notice of the prior orders and filings.
Okay, so 1 second, when we go on the record, then you'll have to say all of that again. I guess my question more specifically was, without asking for contempt, are you asking me to grant the relief that you're requesting only in Exhibit A? I mean, excuse me, Exhibit 1.
I'm also under the understanding that the OHG's filed a revoke of community supervision.
Okay.
So whatever the judge decides, I can do the proposed order if you need me to.
All right, state, what's the date of you all's motion to revoke?
April 1st, 2025, Your Honor.
Okay, let's see. So both of those are set today.
Your Honor, we haven't been noticed on the revocation of community of supervision, or at least it wasn't set for today. All we've been set for was the motion for enforcement.
Okay, the only setting I see on the motion to revoke is from June 24th of last year, and that was in front of the 4D court. Am I missing something?
It was referred to the district court September 5th of 2025, Your Honor.
Okay, did you all do notice, was he sworn in to appear for today?
I'm not sure. I thought both were going to be handled today. So I will check to see.
Okay.
To my knowledge, Your Honor, he was not.
Let me see these notices. I see Ms. Patino filed a notice for,
I couldn't get the citation right for jail time, so I filed notices a couple of times just to try to get him served correctly, but it wasn't successful. So, but I don't know on the OAG's office. I tried to ask them, but they always say that they don't represent me.
correct. And that's true. Let's see. I see the order referring the case to the district court in September. Let's see. November 18th. Go back. On the motion to revoke, Mr. Gallegos was ordered to reappear on November 18th at 8:30. Mr. Samuels, have we done a rights hearing for Mr. Gallegos?
Um, Your Honor, I'm not sure on that. I apologize for that. I'm covering this for Mr. Ramirez. He
It was
informed
the
me.
last time we were in front of Judge Washington.
If I
For-
may,
Go ahead, counsel.
the rights hearing was held on June 24th, 2025. And at that time, I believe Mr. Vidal Gallegos had private counsel that was noted on that order
Okay,
for the next hearing.
thank you. Attorney Samuels, from what I can see, he's been ordered to reappear, even from the 4D court on the state's motion to revoke supervision.
Okay.
So both motions would be properly set because he was ordered to reappear.
Yes, Judge.
Okay. All right, now that we have that figured out, so Ms. Patino, you waived opening. Attorney Samuels, would you like to make an opening statement?
Yes, Judge.
All right, you may
Um,
proceed.
I'll keep it brief, Your Honor. We're here today for an enforcement action. My client is, we will admit, a little behind on child support. However, there are mitigating circumstances. For a period of time, Mr. Gallegos did have full control of the oldest child for a period of a year. He was in primary conservatorship of the oldest child. And then not only that, was uh, ex he was doing more than the standard possession schedule for the other two during that period of time. And I don't believe, and we will show through testimony, that incarceration or removal of the community supervision would not be in the best interest of the children, as his presence in the children's life would not be in the best interest of the children.
Thank you, counsel. All right, state.
Your Honor, the state filed a motion to revoke the suspended commitment due to the fact that Mr. Vidal Gallegos has failed to follow the requirements of that that suspended commitment. The last payment received on this file was September 22nd, 2025. And due to his failure, again, to follow the requirements of the suspended commitment, the state seeks that his suspended commitment be revoked and that he be committed to jail to serve that 180 days.
Thank you, counsel. All right, and the court takes judicial notice of all contents of the court's file. Okay. Ms. Patino, this is now your opportunity to present your case in chief. You may call any witnesses that you may like, including calling yourself, and you may be your only witness if you would like to do that, okay? All right.
Yes, Your Honor.
All right, at this time, you may call your first witness.
I call Vidal Gallegos.
Okay. Mr. Gallegos, if you would remove yourself off of mute. And Ms.
Yes.
Patino, you may proceed.
Please state your name for the record.
Vidal Gallegos.
Do you also use the names Yo V and V?
Also use the name what?
Also use the name, what, Ms. Patino?
Yo V and then V, just the letters.
Okay.
Yes.
On July 21st, 2022, you were ordered to pay $580 in monthly child support and $125 in medical monthly support, correct?
I believe so.
On April 11, 2024, the court found you in contempt and failing to pay those obligations, correct?
Your Honor, I'm going to object to leading.
Sustain, don't lead.
You were found in contempt. True or false?
I don't recall.
Object to leading again, Your Honor.
Okay, the court placed you on community supervision in order you to pay child support, correct?
I'm going to object to leading again, Your Honor.
All right. I'm going to overrule it because it sounds like she's just trying to get some foundational questions asked. So I'll allow it.
I don't recall that.
Those payments were due every month, correct?
Yes.
You still owe child support arrears, correct?
Yes.
You still owe medical arrears, correct?
Yes.
You received the notice of your half of the medical support for Liam. It's uninsured for the amount of $79.50, correct?
I don't recall.
Um, let's see. You are physically able to work, correct?
Yes.
You are listed as a barber on the barbershop website, correct?
Yes.
You maintain your Instagram and promoting your barbershop services, correct?
Don't really promote, but I have an Instagram.
You accept barber appointments, correct?
Yes.
You earn income from those appointments, correct?
Yes.
In my exhibit 4, you reflect deposits for the 2025, correct?
Yes.
Your child support obligations were due those same months, correct?
Yes.
Nothing on those records reflect those funds were legally restricted from being used for child support, correct?
I'm gonna object to leading again, Your Honor.
Sustain, rephrase that question.
Mm. Does the record show anything restricting those payments couldn't be taken out of your account, correct?
I'm gonna reiterate my objection again, Your Honor.
You were still
Hold on 1 second. Does the record show anything restricting those payments couldn't be taken out of overall?
You were still working working during those same time periods, correct?
What periods?
In 2025, on the exhibit 4.
I can't see the exhibit.
May I
You may
share?
share your screen.
Okay, let me do that really quick. Sorry. Okay. Okay, can you see my screen?
No. There is
Okay. Okay. So this is my exhibit 4. And these are the dates right here, which is February 18th through 2025. And my question was, hold on, I can't even. Do you kind of remember now? Because I don't know how to switch or do both at the same time. Let me see. Hold on.
Do you need me to read back the question?
Yes, please. I'm sorry, Your Honor.
That's okay. On the exhibit 4, sir, she said you were still working during those same periods. Is that correct?
During the February, the one she's showing? Yes.
Do you invest in any stocks or bonds?
I used to. Yes.
Okay. Sorry, Your Honor. I was just trying to get back to my page. During discovery, you answered those responses under oath, correct?
What was that?
The discovery responses you responded under oath, correct?
The discovery responses?
Mm-hmm.
What? I
Where we
don't.
asked you to produce where you were asked questions, like your admissions or your interrogatories, all of those were done under oath, correct?
You asked for those. Yeah, you have them already. Yes.
But were they done under oath is what I'm asking.
I don't recall or I don't understand.
Okay, I pass the witness, Your Honor.
Okay.
I
Attorney
do.
Samuels, would you like to ask your client any questions, or did you want to wait to call him in your case in chief?
I'll wait to call him in my case in chief, Your Honor.
Okay, state.
Thank you, Your Honor. Mr. Vidal Gallegos, would you agree that the last payment received on your file was September of 2025?
I believe so.
So it would be correct that you have not made a payment now for over 6 months?
Yeah, I believe so. Roughly around there, yes.
I'll pass.
Right, thank you. Okay, Ms. Patino, you may call your next witness.
I would like to call myself to the stand, Your Honor.
All right, and before we proceed, just let you all know how much time you have left. So it was set for a 30-minute hearing, so you all have 10 minutes aside. Ms. Patino, you have 4 minutes and 12 seconds left. Attorney Samuels, you have 9 minutes and 1 second left. State, you have 9 minutes and 2 seconds left. Okay, Ms. Patino, you may proceed.
Thank you, Your Honor. My name is Kristen Patino. I'm the movement. I am the sole managing conservator of my 3 sons, which is Javen, Aeneas, and Liam Gallegos. On July 21st, 2022, the final order respondent was to pay $580 a month, $125, and medical support 50/50 with the medical and dental expenses. My youngest son was recently diagnosed with focal epilepsy. So it's increasing my medical and financial responsibility I manage. Since the parties have separated, I have secured housing, employment, and remaining solely responsible for the children's day-to-day care and expenses. Although my support system is in New Mexico, I chose to remain in Dallas so the children could continue maintaining a relationship with their father. On April 11, 2024, the court found the respondent in contempt, ordering him to community supervision. Despite that opportunity, the respondent continued failing to pay the court's order. Exhibit 4 reflects deposits, transfers, financial activity, and during periods of support obligations remained unpaid. My Exhibit 6 contains screenshots from his Instagram page and his barbershop website. My Exhibit 11 reflects the medical expenses for Liam, which was not paid, remains unpaid. And then my Exhibits 11 and 16 are the courts where he says that he made a payment of $2,000, but it was only reflected $1,000 on the OAG payment record. And then Exhibit 5B is just my enforcement related costs that I've had to come up with to pay for. And I just asked that those be relieved. I know he said that my oldest son lived with him, but that was for school purposes only. Once school ended, he would return back to me. And it wasn't a year, it was 6 months. I was paying all of his medical records, all of his phone bills, the medical, and those reflect in my exhibits also. Of the bills that I continue to pay where he says that he had him in his care. But that was just for school because the school closed down in Deep Ellum and we wanted him to continue playing soccer. So the school that we chose was next to his, and I wanted him to be closer with his dad, but he showed that in class with him, he didn't exceed or do where he was at. So he did come back to me, but that time period was not only for 6 months and only during school. I continued to stay in contact with the school the whole time. I facilitated that whole movement, and he's back home. All three of the boys have been with me. Um, well, my other two boys have been with me the continued amount of time, but my oldest he's in teenage years, so we're still trying to figure out what's best for him. And then for these reasons, Your Honor, ask the court to confirm arrears, enforce prior court orders, award costs, and grant any additional relief the court deems appropriate.
Thank you so much, Ms. Patino. All right. Anything further from this witness?
Aye.
All right, so Ms. Patino, do you rest?
Yes, Your Honor, I rest.
Okay. Attorney Samuels, you may call your first witness.
Respondent calls Mr. Vidal Gallegos.
Okay, you may proceed.
Mr. Gallegos, I know you already stated your name for the record, but can you state your name for the record one more time?
Vidal Gallegos.
All right, Mr. Gallegos, we have 3 children here before the court. Is that correct?
Correct.
Okay. What is the name of your oldest child?
Javian Gallegos.
Okay. And since the original order in July 2022, has there ever been a period of time where that child has lived with you primarily?
Yes.
When was that?
That was the school year of 2023, 2024.
And how long did he live with you?
He lived with me that whole year, the whole school year. So from the August 2023 all the way to the following year when school ended, which was in May.
And did Ms. Patino provide any child support to you during that time?
No.
And who provided a majority of the support during that time for your oldest child?
Myself.
Okay. And for your other 2 children during that time, what was your possession schedule?
It stayed the same, as in I get them every other weekend.
Okay. Did you ever see your children more time than what you were ordered during that period, during that year time frame?
Yes.
Okay. And during that time, did you seek to modify or change your child support obligation?
Yes.
Okay. Was your child support obligation modified during that period of time?
No.
Okay. All right. And are you aware that we're here today for the potential of removing the community supervision, and that there's a potential that you would be placed in jail for the lack of payment of child support?
Yes.
Do you believe that that would be in the best interest of the children?
No, they will not.
Do you believe that your presence in your children's life is to their benefit?
100% yes.
Why do you believe that your presence in your children's life is for their benefit?
Because one, mother doesn't have a vehicle, so I'm the one transporting them to wherever they have to go. And two, I don't have she doesn't have a vehicle where she could take them to school, so my kids have to walk to school. So I'm trying to work on that where I could take them to school, and they have
No
not been
objection,
playing.
Your Honor.
Okay, what is your legal objection?
Relevance.
What is the relevance, Attorney Samuels?
Your Honor, we're here on whether or not he should be placed in jail and whether or not that's in the best interest of the children, the impact on whether or not his presence would better be in the best interest of the children.
He doesn't take them to school.
Sustain.
I'll move on, Your Honor.
Okay.
Mr. Gallegos, are you aware of the current amount of child support that you're in arrears?
Yes.
Do you have a plan for getting caught up on that amount of child support?
Yes.
Are you currently employed?
Yes.
And are you able to make the child support amount of $580 a month?
Yes.
And if you are incarcerated, would you be able to make that payment?
No.
If you are incarcerated, would you be able to maintain your employment?
No.
If you are incarcerated, would you lose your current employment opportunity?
Yes.
Where do you currently work, Mr. Gallegos?
I work at the Hamptons Barbershop.
How long have you been working there?
I've been working there for about going on 5 years now. Also, too, can I state the reason too why support was kind of stopped given to her because there
Objection,
was a change.
relevance.
Yeah, I'll stop you there.
Oh, okay.
Overrule, it is very relevant.
Mr. Gallegos, I guess I'll have you continue to testify. What was the reason why support was halted in
Uh,
2025?
It was halted because there was a change of the barbershops. So the owner, he had two barbershops and I was working at the second location. But unfortunately, they were raising rent on him, so we had to move barbershops back to the original shop. So it kind of affected me with my clientele and the way I get money as well or make more money is with a lot of walk-ins. It's a barbershop, so I have to get as many walk-ins as I can get. And with that transition, it kind of set me back a bit from how much I really make. So as of now, I'm barely starting to get back into like how much like I would make. So I'm able to make the support payments now because I feel like I've gotten to a point where like okay, the walk-ins are getting higher and my clientele is getting back to where I was at before.
And are you an owner of the barbershop or are you an employee?
I'm an employee.
And so if you were incarcerated, would your employment terminate or are you aware if it would terminate or do you know if it would?
No, yeah, it would affect me. That would terminate me. Yeah.
Okay. All right. Are you asking the court to grant you any kind of credit for that year that you had your oldest son um, living with you primarily?
Yes.
Objection, Your Honor.
Okay, what is your legal objection?
Relevance, he didn't provide any documents or evidence stating that.
Well, he did provide evidence. He provided testimonial evidence. That's still evidence. The court will determine and give it its proper weight. So overrule.
May I proceed, Your Honor?
Yes.
And Mr. Gallegos, now that you kind of spoke on this a little bit, now that the shop has more than one location, and now that it's kind of up and running more efficiently, are you more capable of getting back on track to pay child support?
Yes, I feel like now I am.
Okay. And your last payment was in 2025. Is that accurate?
I believe so, yes.
And that was roughly a year ago.
Yes. I think she said like September, 2025.
And September 2025, that's about 7 months ago. Is that correct?
Yes, roughly yes.
And when did the changes at the shop occur?
They occurred roughly around that time, around September. Yeah, the end of September. That's when it started. The transition started happening.
Okay, so I want to kind of lay out the timeline to the court just so it's all clear. Your son came to, and correct me if this sounds incorrect. Your son comes to live with you, 2024. Your oldest son comes to live with you, 2024. So you begin to incur that expense, and then right around summertime, he goes back living with his mother. Is that correct?
Yes.
In 2025, and then in September of 2025, your shop goes through a change. Is that correct?
Objection, Your Honor, leading.
Sustained only.
Understand. I'll rephrase. So your testimony is that in 2025, your shop goes through a change right after your son moves back. Were there any other changes that were going on in that time frame?
Yes.
What are the changes?
Oh, I'm sorry. No, I thought you were asking. Yeah, that was the change that the barbershop was that were transitioning. Like they were closing down that barbershop I was working at and then transitioning back to the original one, to the first one he opened.
No further questions, Your Honor.
Okay. State.
Thank you, Your Honor. Mr. Vidal, so I can get an understanding, you said you had the oldest child school year of 2023 till it ended spring of 2024?
Yes, that was his 8th grade year. Yes.
Okay. Now, your suspended commitment occurred with the hearing that took place April of 2024. Is there a reason you did not address you having possession of that child at that time?
I'm new to all this, like support systems and how everything works. So I don't know how any of that works. So I didn't know I was supposed to like let you guys
And
know.
you were appointed a public defender for your enforcement hearing, correct?
I don't remember.
Do you remember signing that suspended commitment? It was your signature and your public defender signature?
I signed a lot of stuff. I just don't remember.
Okay.
It probably was, yeah.
Now, would you agree that our record shows as of April 30th, 2026, you're in child support arrears of $26,359.38
Yes.
and medical support arrears as of April 30th, 2026, $5,479.26?
Yes.
And agreed that you have not made a payment since September of 2025.
Yes.
Now, if the court grants the judgment for child support arrears, the state proposes that you would start paying that off at $182 a month, beginning June 1st of 2026. Is that something you would be agreeable to?
You said paying what? I'm sorry.
Paying the child support arrears monthly of $182 a month, beginning June 1st of 2026. Is that something you're agreeable to?
Yes.
If the court grants the medical support arrears judgment, the state proposes that you would start paying that off at $78 a month, beginning June 1st of 2026. Is that something you would be agreeable to?
Yes.
And do you understand that these payments are in addition to your current child support amount of $580 and medical support amount of $125?
Oh, that's on top of that. Okay. Yes, I believe so. I can, because I need to catch up.
I will pass, Mr. Vidal Gallegos.
Thank you. State, would you repeat the arrearage for the medical support again?
$5,479.26.
Thank you. And just making sure I wrote down the child support correct, $26,359.58.
38 cents, Judge.
38. Thank you. All right. Okay. Attorney Samuels, you have 7 seconds left. Do you have any additional witnesses?
No, Your Honor.
Okay. Ms. Patino, you have 7 seconds left. State, you have 5 minutes and 52 seconds. You may proceed.
Thank you, Your Honor. I will call Ms. Patino. Ms. Patino, are you in agreement that the child support arrears as of April 30th, 2026 is $26,359.38?
Correct, yes.
The state does propose that Mr. Vidal Gallegos start paying that off at $182 a month beginning June 1st of 2026. Is that something you're agreeable to?
Yes, yes.
Okay, and do you agree that the medical support arrears as of April 30th, 2026 is $5,479.26?
Yes.
And the state proposes that Mr. Vidal Gallegos start paying that off at $78 a month beginning June 1st of 2026. Is that something you're agreeable to?
Yes, I also wanted to include the 79, his portion of a medical, but I don't know if that's included on there or not.
The state did not plead any reimbursed medical. So I'm just strictly asking you about the medical arrears based on what Mr. Vidal Gallegos was ordered to pay monthly in
Okay.
medical support. Are you agreeable?
Yes.
Okay. I will pass Ms. Patino.
Thank you. State, you may call your next witness.
The state does not have any other witnesses, Judge.
All right. According to mother's testimony according to father's testimony, and mother admitted it, father would be entitled to a credit for at least 6 months. So, would the state recalculate that, giving him a credit for 6 months?
Okay, if the court is going to give him credit for 6 months, then the arrears would have to be based as of yesterday's date, and that changes both the medical and the child support. But
Okay.
I will, and it's just for the one child.
Correct. Correct, because based on his testimony and mom's, what they did agree on was it was a 6-month period, not a year.
Yeah, Your Honor, it was the whole school year, so I'm kind of like, I don't know how is the 6 months.
Okay, so you testified.
Mhm.
I don't have any exhibits from you
Oh,
to
okay.
show that it was a whole year, but what she did testify to was at least 6 months.
Okay.
And I also have a question for you, Mr. Gallegos. You said that you're now able to get back on track when your attorney was asking you about catching up. You're now able to get back on track with your child support payments?
Yes, ma'am. I should be able to.
Okay, how long have you been able to get back on track before today?
It's recently, maybe about like close to like 2-3 weeks ago. It's just barely picking up right now. The thing is, like in the work that I do, we have a period of time where it's like it slows down certain times of the year. So from the beginning of the year all the way till maybe like May, that's when it's like it's slow. It like fluctuates, but it's more down than up. But closer to summertime, that's when it starts picking up.
Okay, thank you.
And Your Honor, what is the time period for the credit possession?
Now that's a great question. I don't know the exact dates, but it's going to be in that 2023, 2024 school year, according to his testimony. So what is that, September through
May, possibly?
May?
Okay.
Well, if it's September and for 6 months, it'll be through March. May would actually be 8 months.
Okay.
It was September 21st through May 28th. I got them back right before the summer.
Okay, So it would be close to that 8-month period. So,
I
Mr.
was-
Gallegos, you're getting a credit for 8 months.
Thank you, Judge.
You're welcome.
All right, and Your Honor, the child support arrears as of yesterday's date would then be 26,939.38. Giving him possession credit for that one child for 8-month period would give a credit of $986.51.
Okay.
Can you repeat that number? Sorry.
Child support arrears as of yesterday's date is $26,939.38. Possession credit for the one child for the 8-month period is $986.51. And so the child support arrears after possession credit is $25,952.87. The medical arrears as of yesterday's date is $5,604.26.
All right. Okay. Is there anything further from the state?
Your Honor, we'll just ask for a judgment and a payout amount. If the court declines to revoke our motion to revoke, I would propose if the court then would allow either is it to extend, we can extend the suspended commitment for an additional 2 years.
Right. Thank you, state. So what the court is going to do at this time, Mr. Gallegos, you understand the severity of this, right?
Yes.
I'm going to give you an opportunity to catch these payments up and not revoke your probation today. According to your testimony, you can catch it up. I'm going to grant the state's request to extend your probationary period for an additional 2 years. And I'm going to grant the recommendations that the state has given me as well. So I'm going to confirm your arrearages as of yesterday, May 10th, 2026, in the amount of $25,952.87. That's giving you a credit for the 8 months, that your oldest child lived with you. That credit is $986.51. Medical support arrearages as of yesterday, May 10th, 2026, is in the amount of $5,604.26. The payout amount on each judgment will begin on June 1st, 2026. Payout amount for child support will be $182 a month. And the medical support would be an additional $78 a month. As the state explained to you, that's on top of the child support payments and medical support payments that you have to make per month, okay?
Okay.
So what the court is also going to do is order you to report back, just to make sure that everything is going like it should be going in terms of you making regular child support payments, okay?
Okay.
All right, let me give you, if you all will grab your calendars. Right, so I will reset you all for a report back in August. That should give you at least 3 months to catch up some of the payments, okay?
Okay.
All right. So everyone, I have August the 10th and August the 24th. On the 10th, you have a 10 a.m., a 10:30, and 11 a.m. And on the 24th, you have 9 a.m. through 11 a.m. If those dates don't work, I also have August 31st, September 14th, and September the 21st.
August 24th works good with me.
Okay.
Me as well, Judge. Does that work for you, Mr. Gallegos?
Yes.
August, hold on. My calendar doing something funny. Hold on. Okay, so August 21st, does that work for the state too?
I thought it was the 24th. Is it the 21st or the 24th?
It's 21st. I may have misspoken. I'm sorry.
I thought it was the 24th. I'm sorry. You said the 21st?
21st, yes. Oops, hold on. I'm in the wrong month. Hold on. It went to September. It is August 24th. I'm sorry.
That works for the state.
Okay.
Yes, I agree.
Okay. At 9 a.m.
That works, Your Honor.
That works,
Yes.
Your Honor.
Zoom or in person? I know I'm
Mm.
asking you a lot of questions.
Zoom, please.
Okay. Try to add it to the calendar.
So Your Honor, I didn't know if you ruled on my attorney fees or my litigation fees or.
You didn't testify to any fees.
I did I mentioned my exhibit 5B, which is the total cost of my total cost summary.
Hold on. I mean, I heard the exhibit. Let me see what you actually testified to, though.
Okay. Towards the end, I said, at the very end, it said, or I said, for these reasons, Your Honor, I respectfully request that the court confirm arrears, enforce prior court orders, award costs, and grant any additional relief that the court deems appropriate.
Okay, what is the cost of those expenses? And that will be for the filing of the motion and any service that is that was performed on Mr. Gallegos.
$1,252.97.
$1,252.97.
Correct.
Okay. You know, you put 31, Joey.
Well, just because attorney one, it puts that number.
Oh.
So that attorney one is, I need to write something first and then it won't. That's that.
Okay. So Mr. Gallegos, I am ordering you to reimburse costs to Ms. Patino in the amount of $1,252.97. That's for the cost of her actually bringing this motion. On this motion for enforcement against you with the motion, the cost of service. How much time do you need to pay that back to her?
Yeah, I can't pay that right away, so I need as much time as I can, if possible.
So what I'll do is I will make that payable I will make that pay, can give you 6 months and make that payable in November. Get a calendar. Is there any particular day of the week? I know you're a barber, so your money, you get paid every day. Is there any particular day of the week that works best, like a Monday, Tuesday, or a Friday or something?
Um, yeah, I mean, you could do a Monday. That's fine.
Okay. Okay, let me go to the calendar.
Or can I object to these fees? She has the service costs for her failure, which were accrued for her multiple failures for service that we had to get reset on these for. I think we had 5 separate settings where she failed to serve us multiple times. And I think she has on here the multiple attempts that she had on there.
And that's what I had to do
Well,
to
she
serve her.
still had to defend the motion. I can't penalize her for her lack of really not knowing or understanding fully how to do. I wouldn't do anyone like that. She still had to prepare it in order to do it, to bring it here today. I mean, she didn't do it correctly in terms of the contempt, which is why I couldn't hold him in contempt on her motion. But yeah, she's still entitled to those fees.
Understandable, Judge. There's just a lot of printed copy pages, like copies.
Yeah, I mean, it would be the same, counsel, if you were asking for attorney's fees from her.
Understandable, Judge.
Okay. Mr. Gallegos, I have November, you said a Monday. So there's November the 2nd, the 9th, and the 16th. Those are all before Thanksgiving. Is there anyone in particular you would like?
The 16th is fine.
Okay. So I'm ordering you to pay that amount back to Ms. Patino by November 16, 2026. You can break it up in payments. It doesn't have to be a lump sum. As long as you make the total payment by that day, you'll be fine. I would encourage you to do it by cashier's check or money order, just so you can keep your own record and receipt of it, okay? And I have the report back date,
How much was it? The
$1,252.97. Once the order is prepared, then State, are you preparing the order for me?
Yes.
Okay, so once the order is prepared, Mr. Gallegos, the state will circulate it to Ms. Patino as well as to your attorney, and it'll have that amount listed in there, but it's $1,252.97.
Okay.
Okay?
And to be paid by November 15th, 2026?
November 16, 2026, yes. And on the report back date, Mr. Gallegos, I am ordering you to reappear on Monday, August the 24th, 2026 at 9:00 a.m. You are ordered to reappear via Zoom, the same Zoom code that you used today, 688-044-0164. Your failure to appear may result in a capious warrant being issued for your arrest, okay?
Okay.
Do you have any questions about it?
No.
Do you have any questions about any instructions that I've given you so far?
No.
Okay. All right. Is there anything further for the record?
No, Your Honor.
All right. Thank you all. State, how much time did you need to prepare the order? I forgot to ask you that.
Don't need much time. I can get it before the end of the week. Does Your Honor want it to be brought in person to sign, or it can be e-filed? I'm not sure the process for this court.
Thank you for asking. Email it to my coordinator. That's the quickest way to do it. I can I can put you on the entry docket for next Friday, the 22nd.
Okay, and are you requesting that everybody sign off?
Not necessarily. The only signature that really matters is mine.
Right.
So as long as it's circulated and everyone has an opportunity to look at it, make objections, I think that'll be the best way to do it.
Okay.
And I am putting you all on the entry docket right now. So the entry docket will occur in front of Judge Lee, the associate judge. Now, if everyone looks at the order, signs it, or, doesn't sign it, you don't have to worry about this date, but it is on next Friday, May 22nd at 9:30. The dismissal docket is on Zoom. That code is 961-1106-4392. And I am dropping that code in the chat just in case everyone didn't get a chance to write it down. And it's also on the course website.
What is that hearing for, Your Honor? I'm sorry.
That's the entry date. So the state is preparing the order.
Okay.
So by that day, the order should be entered.
Oh, okay.
Okay?
Thank you, Your Honor.
You're welcome. Thank you all.
Thank you, Judge. May we be dismissed?
Yes, you're excused.
Thank you.
You're welcome. All right. Yes, ma'am. Good morning. How are you? Good.
I'm asking for, my spouse be served by social media or at, having me dropped off at his job.
Okay.
I did file it, with the office on me.
Let's see. Hold on 1 second. My computer is running real slow this morning. And happy belated Mother's Day to you.
Thank you.
You're welcome.
I didn't get the states in that last case, the Gallego, where did she send it? Did she just send it to you,
Which one?
the attorney? For Gallegos, the states exhibit?
Exhibit. Jean sent it to me. I can forward it to you.
Okay, yes. I have her other 20 of them.
Okay, States Exhibit A. All right, I just sent it to you. You're welcome. All right. Oh. All right, so on the motion for substituted service, do you have the, let me see, I can, trying to read what it says. So there has to be an affidavit attached to your motion showing all the attempts to serve him. I don't see it.
It should be the last 2 pages by the constable.
Okay. Ooh, Lord. Do you have that page?
No, I don't. I just filed it and I didn't get a copy of that page.
Okay, that's not clear on the computer.
Okay.
It looks, I can show you, it looks like a bunch of screw.
Okay.
So if you could get me a clear copy of that so I can actually read it,
Okay.
and then I'll be able to sign off on the the substituted service. I need an order too.
What do you mean order?
So you filed the motion. Hold on, let me see what you filed here.
The order for substitution?
Yeah, that.
Uh,
I'll need that too, but I
that
need,
is-
hold on, where is it? Oh, okay, it's at the very back. Yes, so if you would just give me those attempts, I just need that page.
Oh.
That's all I need. Okay,
Okay, thank you.
you're welcome. Yes, ma'am. Okay, 19772. How are you?
Good, how are you? You look very tall up there.
Huh?
You're very tall up there.
Oh, trust me, I'm not.
My attorney sent me in here on a quest.
Okay,
To withdraw on one of our clients filed, I believe it's in your queue.
okay, what is the case number?
It's TF 24
Uh-huh.
07008.
Motion to withdraw, okay, and I see the 10-day letter. All right, did you email it to my coordinator?
We
Your
called
order?
them this morning, and they said it was in the queue.
No, the coordinator.
Yes,
Brittany?
yes.
Okay,
And then we emailed it again, so it's been emailed twice.
okay, because sometimes the things that you put that are put in that queue don't actually make them to me. So that's the reason why we asked that you submit it to Brittany.
Yes, I believe on the 7th, so Thursday, we sent it to her.
Okay, let me see. Let me make sure I didn't already sign it. I don't see it. Let me see if this will, let me try something else. Three, 4 0 7 0 0 8. Let me see if it'll allow me to save it from here.
Yeah.
Pull it up. All right, I just signed it and I am emailing it to my coordinator and the clerk right now.
Okay.
So you'll have it in your inbox.
Awesome. Thank you so much.
You're welcome. Have a good day.
You too.
Thank you. 0 7 0 8. Thank you. Okay, thank you. All right, it's signed. Okay. The order. Just, yeah, just grab it from her. Oh, you know what? I don't even know why. Hold on. It's 15967, right?
Yes.
Okay, I'm about to sign it
Oh.
here. Wait a minute, why is it only one? Let me see how your order looks. It's only one page right here, and I think it's supposed to be two.
Yeah, this is the order. And then I have an affidavit in motion.
Wonder why the. I don't know why I did that. So one more thing. This order, I mean, this page here, The clerks down there, ask them to scan this in, then I can sign it electronically and it'll go to your mailbox, your inbox.
Okay.
Yeah, just this page. This is on there, not this one for my signature.
Oh.
Okay.
And do I come back?
Yes, ask to speak to Miss Lashenda,
Okay.
because then she'll be able to email me that page. Like after she scans it in and attaches it to this, then I can electronically sign it and you're good.
Okay.
Okay,
Thank you.
you're welcome. All right. Good morning.
Morning,
Am
Judge.
I
Good
missing-
morning, Judge.
Good morning. Am I missing? Wait a minute. There is a Cantu here. I'm admitting Willie too.
Yes, Judge.
Okay, I thought I was seeing doubles.
Yeah, there's two of us.
Okay. Am I missing anyone else from this case?
Not on my side, Judge.
Not on mine either, Your Honor.
Okay.
Hi, Cassie.
Hi, Joy. Happy Mother's Day, Judge.
Thank you.
Monday, post Mother's Day.
Oh, it's okay. I've been telling everyone post.
It's May. It's May.
Yeah,
Fathers get June.
Happy Mother's Month.
Yeah,
Thank you.
fathers get June, mothers get May.
That is so true. So true. All right. Pull this up. And I have some exhibits too. Give me 1 second.
You know, Willie's just showing off and growing his hair so beautifully long.
Willie. Oh, your hair is long.
Showing off now. Mr.
Joey said you're showing out now. You're just showing off.
Oh, yeah. I got tired of cutting it.
I love it.
Being in the Marines all them years in a cop, I said, I'm gonna let it grow.
Nice to meet you in person. Yes, it is still the morning. Did you need me? Yes, is that Ariano? DF 2120145?
Yes, Judge.
Yes. Nobody has checked in yet. So, okay, you'll be the first. Yeah. And you have some time because we have 2 more that are in front of you.
Everybody can come back?
Yes, ma'am. You're welcome. So I have, oh, not you. I'm sorry. So I have mother's exhibits, looks like 1 through 26.
That's it, Your Honor.
All right. And then I have father's exhibits 1, 2, 3. It's like 6 of them.
Yes, Judge.
Okay. Okay, and this is the motion for enforcement from March of 2026.
Yes, Your Honor.
All right. All right. So, Joey, can you type something? Oh, okay. I see you. Yes. All right. Who will be doing direct and cross, just so I can make sure that one attorney is speaking at a time?
Willie's for observing only, but
Oh,
Judge.
okay.
Willie's gracing us with his lovely hair and presence today.
Okay.
Yeah.
Okay, I knew it had to be something like that. All right, and Attorney Hans. All right. You ready, Joey? Both sides ready to proceed?
We are, Judge.
Yes,
All
Judge.
right. We're on the record in cause number DF 1917792. Councils, will you please announce for the record?
Cassie Hines on behalf of the movant and petitioner, Carolina Nino.
Chris Cantu for the respondent, Mr. German Gonzalez.
Thank
And
you.
Willie-
Go ahead, Mr. Cantu.
And Willie Cantu also for the father, Your Honor. Thank you.
Thank you. And those who intend to testify, would you please raise your right hands? Do you both swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, I
Yes.
swear.
Thank you. All right, we're set here today on moving mothers' motion for enforcement of electronic access and requests for makeup possession time. Prior to going on the record, there was some exhibits that were pre-admitted. They will be admitted at this time. So we have mothers exhibits 1 through 26 and fathers exhibits 1 through 6. Is that correct?
Yes, Your Honor.
Yes, Judge.
Okay. You all are set at 15 minutes aside. That will include any opening statement and closing statements, should you all choose to make them. Attorney Hines, at this time, would you like to make an opening statement?
Very briefly, I would, Your Honor.
Okay, wait a minute, 1 second before you start. Hold on, off the record. Yes, ma'am. Okay, hold on. Let me take care of someone in the courtroom real quick.
Yes, Your Honor. Thank you.
You're welcome. You're welcome. It hasn't come through yet, but as soon as it's signed, I'll sign it and send it to back to the clerk, as well as my coordinator. My coordinator will electronically send it to you. No, ma'am.
Okay, thank you.
You're welcome. Have a good day. Thank you. Okay, Attorney Hines, sorry about that. You may proceed.
Thank you, Judge. Very briefly, we're here today just because we're seeing a pattern, and the evidence will show that father has consistently, at least 29 times, denied my client electronic access. The court order under temporary orders requires both parents to make the child available between the hours of 5 and 8 p.m. Each day. The child's 9. It's a young girl, so that this is continuous contact between both parents, Judge. The evidence will show that this has just been an issue that we want to address while we're in front of this court. We're afraid that father won't abide by orders once this case is closed. We are set for trial in June. The enforcement today, though, is about these specific 29 violations. Thank you, Your Honor.
Thank you, counsel. Attorney Cantu?
Yes, Judge, just briefly, may it please the court. We're actually here, Judge, on this temporary order on a very vague and ambiguous provision where you'll see that although father has the right possession, mom is trying to argue that somehow she has missed 29 or that father has failed and refused to make the child available on a provision, Judge, that is a supplement to possession, which I believe the evidence will show is in violation of his right of possession. And further, it is a provision that that states no specific dates, times, and instead gives a 3-hour period of time where apparently the child is supposed to be made available for electronic communication. Some key terms that the court should pay attention to is the electronic communication term, the specificity of this order stating a 3-hour window of where a parent can have up to 20 minutes of conversation or access to the child. And we believe, Judge, that the evidence doesn't show that this is unenforceable. It violates possession of a parent, and there is going to be no proof that for every single second between 5 p.m. and 8 p.m., any parent would possibly be able to prove that this child was made available or unavailable to the other parent, because this provision is ambiguous and vague and talks about different forms of communication. Thank you, Judge.
Thank you. Attorney Hines, hold on 1 second. Let me do something really quick. Excuse me, the Odyssey started acting up on me. Hold on 1 second. Okay, we was able to work that out. All right, Attorney Hines, you may call your first witness.
Thank you, Judge. I call Carolina Nino.
All right, you may proceed.
Thank you, Your Honor. Ms. Nino, can you please state your full name for the record?
Carolina Nino.
And you are the mother of the child SDG in this case, correct?
Yes.
How old is she?
9,
And what grade is she in?
3rd grade.
And German Gonzalez is the father of your child, correct?
Yes.
We've submitted Mothers 1, which is a relief of everything that you're asking for the court to grant today. Is that correct?
Yes.
Your Honor, permission to share the screen?
Yes.
And Ms. Nino, it's correct that we're here seeking the court to grant you some makeup time for the times that you have missed. Is that fair?
Yes.
You're asking the court to order Mr. Gonzalez to post a bond for violations of the order. Is that fair?
Yes.
You're not asking the court today to send him to jail, are you?
No.
And you're also asking for your fees. Is that correct?
Yes.
Ms. Nino, are you familiar with the temporary orders that were entered in this case in February of 2025?
Yes.
And in that temporary order, there's a provision regarding electronic access, correct?
Correct.
And what is your understanding of what was required of both you and the father regarding making your child available?
That we both help facilitate telephone communication with the child during each of our possession periods for 20
Okay, and
minutes.
so for 20 minutes, and did you understand what the time window was?
Between 5 and 8 p.m.
Okay, and how long the call was supposed to last up to, you said 20 minutes?
Yes.
Did the order require the parent in possession to assist in returning a call if a call was missed?
Judge, I'm going to object on 2 grounds. 1, as to leading, and 2, as to relevance. Their motion, which must plead specifically the non-compliance of the alleged provision, must be in the motion. Their motion does not complain about any facilitation. So I'm going to object as to relevance and for something they did not plead.
Okay. Sustain as to leading, don't lead.
Yes, Judge, thank you. Why do you think these calls are important between you and your daughter and German, Mr. Gonzalez and your daughter?
To help both parents still have some kind of contact with the child while she's with the other parent.
Okay, when Mr. Gonzalez had possession of your daughter, did you attempt to call her?
Yes.
And we'll go through each specific violation, but what time frames were you attempting to call your daughter when she was with her dad?
Between 5 and 8.
What device did you use when you were attempting these calls?
My phone, I would try to call Dad's phone or Sophia's phone.
Sophia has a phone, correct?
Yeah, she has or had one. Yeah.
Okay. When calls weren't answered, what did you do?
I would call and message Dad.
Okay, and so I'm gonna turn your attention again. These have been pre-admitted. But starting on July 2nd, did you attempt to call your daughter?
Yes.
How did you attempt to call her?
Either through the app close or to Sophia's phone.
And on the screen, it's Mothers 3, and this is July 2nd, correct?
Yes.
And you asked, I called Sophia, could you please have her call me back?
All right, Judge, I'm going to
Yes.
object to the leading questions.
Sustain, don't lead.
Miss Nino, did you have a call with your daughter that night?
No, I didn't. When I called, no response. Message, no response.
Okay. Moving to Mothers 4 on July 18th. Did you have a call with your daughter?
No.
Did you message the father on Out Close?
Yes.
Yeah, and object to any leading questions, Judge.
Sustain, don't lead.
Miss Nino, how did you attempt that phone call with your daughter on the 18th of July?
I tried to call Dad on his or through app close and Sophia's phone.
And what does your App Close show as far as the calls that were attempted?
That there was no answer to them. They were missed.
And on July 22nd, did you attempt to call?
Yes.
Is that reflected here in your App Close messages?
Yes.
And then again, when did you attempt to call? Do you recall July 26th?
Yes.
Is that all in these App Close messages that are tendered to the court?
Yes.
Mothers 5, did you attempt to call on July 29th?
Yes.
What is App Close showing on July 29th?
That I kept trying to call Dad and Sophia on either their phones and no response.
Okay. Did you have a call with Sophia that night?
No, I don't believe so.
Mother 6. Did you also try to have a call on August 17th?
Yes.
Did you have a call on August 17th?
No.
Mother 7 on August 21st. Did you attempt to call your daughter?
Yes.
Was a conversation had with Mr. Gonzalez on app close?
Well, I messaged him to ask him to call me or have her call me back.
Again, on Mother's 8, a separate issue on August 31st. Did you try to call your daughter?
Yes.
Did you speak with your daughter that night?
No.
On September 1st, did you speak with your daughter?
No.
Was your daughter with Mr. Gonzalez?
Yes.
On September 4th, did you attempt to call your daughter?
Yes.
Did you have a conversation with her that evening?
No.
On September 11th, Mother's 11, did you attempt to call your daughter?
Yes.
Did you have a conversation with her that evening?
Nope.
On Mother's 12, September 20th and 21st, when did you speak to your daughter those evenings?
I don't think I spoke to her that evening. Same thing. Called her, no answer.
Objection is to non-responsive at this point.
Sustain after, I don't think I spoke to her.
Miss Nino, Mother's 13, did you attempt to call your daughter on these 4 different nights?
Yes.
Did you have calls with her on those different nights?
No.
Mother's 14, this is October 19th. Did you attempt to call your daughter?
Yes.
Mr. Gonzalez, where did he tell you he was?
Did I remember he was saying that they were busy?
At some point, did you speak to your daughter later that evening?
No.
Mother's 19. I'm sorry, Mother's 15. Again, November 22nd. Same pattern. Did you reach out for a phone call?
Yes.
Did you have a phone call?
No.
Mother's 16. On December 6th and December 7th, were you attempting to make phone calls?
Yes.
Mother's 17. On December 11th, again, did you attempt to have a call with your daughter?
Yes.
And this is December 11th, correct?
Yes.
When did Mr. Gonzalez respond to you when you were reaching out to him on app close?
I don't think he responded.
So your main area of communication is app close with Mr. Gonzalez, correct?
Yes.
That's court ordered, in fact,
Yes.
correct?
Mhm.
And so you're not getting responses from dad.
Correct.
Mother's 18 again on December 20th. Did you attempt to call your daughter?
Yes.
Was she in possession of father?
Yes.
Did you have a call with her that evening?
No.
Mother's 19. This is December 23rd, right before the holidays. Did you attempt to call your daughter on December 23rd?
Yes.
Did you speak to her that evening?
No.
Mother's 20 on December 26th. Again, did you attempt to call your daughter?
Yes.
Did Mr. Gonzalez facilitate that call?
No.
Mother's 21, again on January 17th and 18th. Did you attempt to call your daughter?
Yes.
Did you reach out to the father to help facilitate that call?
Yes.
Did you speak to her either of those evenings?
No.
Mother's 22, this is January 30th of this year. Again, did you attempt to call your daughter?
Yes.
And did you speak to her that evening?
Nope.
Did you reach out to the father to request facilitation of the call?
Yes.
And the last violation that we have listed is Mother's 23 from February 1st. Did you attempt to call your daughter that night?
Yes.
And did you reach out to the father to facilitate that call?
Yes.
Did he help facilitate that call?
No.
Yeah, I would object, Judge, to any testimony about facilitating the call. That is not something that I pled specifically for in this motion for enforcement. So relevance.
Sustain as to relevance.
Ms. Nino, were these phone call concerns, were these isolated incidents?
I'm going to object as to leading.
No,
Rephrase.
Ms.
Yeah.
Nino, what concerns do you have about not having access to your daughter?
I'm going to object as to relevance for a motion for enforcement.
um,
Okay.
Hold
that,
on one second. Hold on 1 second. Let me read the question back. About not having access to your daughter. Sustain, rephrase.
Miss Nino, why
Mhm.
are you bringing this enforcement regarding missed calls with your daughter?
because, I believe that we're both supposed to be able to check in on Sophia on each of our times, and while I am letting him do it, he does not let me check in and talk to her during his time.
When did Mr. Gonzalez offer makeup calls for these missed calls?
He has not.
Has he been, or what attempts to cooperate with the order has he made regarding electronic access?
I mean, he would say he would have her call back, but that doesn't happen.
And how did these missed calls affect your ability to maintain communication with your daughter?
Well, I mean, there, I go days without talking to her when she's with him. And it just it strains our relationship more as well, because, I mean, there's just no contact during those days.
And why is contact important to you at this age?
Because it helps, I believe it helps show Sophia that we both care and care to check in on her, and that we haven't forgotten about her while she's away with the other parent.
And did you have to hire my firm to file this enforcement?
Yes,
And we started, well, some of these violations go back to which year?
go back to what, sorry?
These violations go back to which year?
2025?
And we've submitted our attorney's fees to this court, correct?
Correct.
And you're asking the court to award reasonable and necessary fees in this case. Is that fair?
Correct.
Pass the witness, Shana.
All right, Attorney Cantu.
Miss Nino,
Yes.
if I heard you correctly, you stated that Sophia has a cell phone, correct?
Yes,
She had one. You took it away in December of 2025, correct?
correct.
And so you bought her that cell phone back in early 2025?
Yes.
And when she's not with you, do you guys text on that cell phone?
Objection, relevance, Your Honor.
This is about electronic communication, and she's asking about communicating with her daughter. I have every right to ask her if she communicates with her via electronic communication, which the order states. This is highly relevant to this, Judge.
Overrule.
Ma'am, I know you're trying to state that Mr. Gonzalez is somehow violating this unenforceable provision. So I'm going to ask you again.
Mhm.
When she had the cell phone, were you able to text her whenever you wanted?
No,
No, you were not.
no.
Okay. When you removed the phone from her, when did you remove the phone from her?
Sometime in December?
Of 2025?
Yes,
You did not tell Mr. Gonzalez. In fact, he had asked you about it, correct?
yes,
Do you
Yeah.
recall stating, which is as an exhibit's already been admitted, do you recall stating that Sophia will no longer have her phone until she learns to respond and answer your calls? Do you remember telling Mr. Gonzalez that?
yes,
Do you recall telling him, I didn't get her a phone for her to tell me she's busy and make up excuses?
yes,
So she has this phone up until you took it away in December, and you're mad because the child's telling you that she's busy and sometimes ignores your calls, and you're going to blame Mr. Gonzalez. Is that
Your Honor,
true?
at this point, I'm going to object to child hearsay.
No, this is her message. This is her statement and Ms. Nino's statement.
Sustain as to the portion about the child telling you that she's busy. Sustain as to hearsay.
So you removed her phone based off what she told you, right? Yes or no, ma'am?
I removed it because in my efforts to try to have some communication with her during Dad's parenting time was still not working.
Yes, ma'am. And she had this cell phone, correct?
She what?
She had this cell phone, correct?
Yeah, for a few months.
When did you first get it for her?
Sometime in April.
Of 2025.
Yes.
I'm going to refer to you. May I share the screen, Judge?
Yes.
Trying to share screen number 3. Can Miss Nino, as it's pulling up, sorry, my laptop's a little slow. Is it sharing properly, Miss Nino? Can you see this?
Oh, now I can.
Okay. You see here where it says this concludes the possession order?
Yes.
And this is attached to your lawsuit. You know Mr. Gonzalez has the right of possession of the child on the first, third, and fifth weekends when school is released until school resumes on Monday, correct?
Correct.
You also know that he has a child on Thursdays each week during the regular school term when the child is released from school until the resumes the next Friday, correct?
Correct.
And so you know he has a child. The child primarily lives with you, correct?
Correct.
You're alleging that there's 29 times the child wasn't made available to you, correct?
Yes.
However, he has a child roughly 160-ish overnights. So you're stating that on 130 other days, you've had the ability to call, text, and communicate with your daughter, correct?
Mom,
Yes or no?
no, because some of
Okay.
those days were not included on this enforcement.
Okay. So you didn't. So you're telling the judge I also didn't include other times, correct?
Correct. And then there's some recent ones that have not been included as well.
Okay. And you see right here, I'm going to refer to this electronic communication. You see how it states above it, this concludes the possession order. So the above states the possession order of when each parent has the right to possession, correct?
Mm-hmm.
Is that a yes?
Yes.
And then it states here electronic communication, right? You see it right there?
Yes.
And it states that it's telephone, messaging, video conferencing, correct?
Yes.
And it states that electronic communication is to supplement possession, correct?
Yes.
It also says that the parent who is with the child shall make the child available between 5 p.m. and 8 p.m., correct?
Yes.
So that the other parent may talk to the child, correct?
Yes.
How many times with all these alleged violations did you call the child or text the child between 5 and 8?
All of the alleged times.
The evidence you just went over does not show any text messages between you and the child, correct?
Correct.
It also does not show between 5 and 8 p.m. every single second being called to see if the child was available, correct?
It's between that window.
Objection not responsive.
Sustain.
Does your evidence show that you called or text or messaged or electronically emailed your daughter every second between 5 p.m. and 8 p.m. on all these alleged dates you're stating? Yes or no?
Yes.
Your evidence shows every single second.
Not
That's what
every
you're telling the
second,
judge.
but
Not every second.
yeah.
Yes, ma'am. Does it show, does this provision here state exactly what dates you're supposed to be able to call the child or text the child or message the child? Does this provision state that? Yes or no, ma'am? You said you're familiar. This is your lawsuit.
Mm-hmm. No,
Does it state the exact dates?
no, not exact dates.
Okay. However, your motion, you provided exact dates, correct?
Correct.
Okay. You also said make the child available between the hours of 5 and 8. You didn't give an exact time of when Mr. Gonzalez was supposed to make the child available, correct?
Well, between 5 and
Yes or
8,
no?
my understanding.
Okay. Ma'am,
Yes.
has there been times where the child was, that Mr. Gonzalez tried to call the child and you didn't make the child available?
Objection relevance.
This,
Sustain,
Judge, may I respond?
sustain.
Okay, ma'am, has there been times where you have violated the order when Mr. Gonzalez is supposed to have the child?
Objection relevance.
Judge, may I respond to that? In the motion for contempt, they're asking for makeup and possession time. I'm allowed to have Her Honor consider why they shouldn't have makeup and possession time if I can show good cause. We have pled that the mom has made violations on dad's time.
That's not before the court today. I haven't seen the pleading that there's been
Again, I don't
violations, Your
have
Honor.
Counsel, you may ask your next question. I already sustained the, I already made the ruling and sustained it.
Yes, Judge. Ma'am, I'm going to go through what has been pre-marked as Exhibit R2. Is this, can you see Exhibit R2?
Yes.
You stated that on July 18th,
Mhm.
you were denied a call as one of your violations, correct?
Yes.
You see here, Mr. Gonzalez, on July 18th, calling you back. You see that?
Yes.
However, on your exhibit, part is cut off, correct?
I don't know.
You don't know if your own exhibit is cut off, ma'am? You just introduced it. So I'll move past that.
Mhm.
So this means Mr. Gonzalez is calling you right back on one of your violations, correct? Yes or no?
Yes.
On July 22nd, you ask about a callback and he states, I'm sorry, July 26th, I'll make sure she calls you today. You see that?
Yes.
You see on July 27th, he says, maybe try my phone, correct?
Yes.
On July 29th, you state, I'm trying to call. He says, I think it's her service. Try calling me. Him trying to work with you, correct?
Yes.
August 17th, try calling my phone. This is another date. You're stating you didn't get your call, correct?
Correct.
Again, your phone call is what you're complaining about, right?
Yes.
You see here at 8:03, she's calling right now. She's available to call you and text you all day. You see Mr. Gonzalez telling you that on the same day you're saying you got violated, she's calling you back, correct?
Correct.
Yet you're showing the judge exhibits that are cut off that does not have this part, correct?
Your Honor, I'm going to object. That misstates the
Okay.
evidence. My exhibit does not cut that portion off.
Which exhibit number is this?
For me, Judge, it's exhibit R2. It's the full messages.
And for me, it's Mother 6. It is a complete copy of that entire conversation, so it misstates the evidence.
Six. Okay, sustain.
Ma'am,
Yes.
you're stating on September 1st that there was some kind of violation. Yet on here, it shows she's calling you. That's German.
Mm-hmm.
It also says you're talking to her right now. Yet you're telling Her Honor that you didn't get a phone call, correct?
Correct.
Okay, but it states right here, Mr. Gonzalez is stating you're talking to her right now. So you did get that call, right?
I don't think I did know.
You don't think you did. You're bringing in enforcement, stating to Her Honor it was completely violated. Now you're saying, I don't think so.
No.
Okay. Ma'am, is it true on times that you've been able to talk to the child over 130 times, Mr. Gonzalez will let you talk to the child longer than 20 minutes?
Sometimes.
Has there been times where he's let you talk to the child for 30 or 40 minutes?
One occasion, I believe.
And this is exhibit R3. This is the time that you're telling German you removed your daughter's cell phone from her, correct?
Correct.
And Mr. Gonzalez has also made you aware that she has an iPad, correct?
Correct.
R4, which is an exhibit that's been pre-admitted already. How many times would you say Mr. Gonzalez has been denied calls by you?
Objection, relevance.
Your Honor, again,
So what's the relevance?
Judge, I'm allowed to I have pled for unclean hands. Ms. Gonzalez is complaining about phone calls that she's allegedly missed. I'm allowed to show that she has the same conduct because she's trying to show that Mr. Gonzalez has some kind of intentional, she stated, we should both be allowed to do this. If she's complaining that he's somehow intentionally preventing her from calling, she's doing the exact same thing as she's alleging. I'm allowed to show her honor that this provision is obviously vague and ambiguous, or that she's doing the same exact thing. And this is help showing the proof that she does the same thing.
Your Honor, again, it's an inappropriate legal vehicle and a separate enforcement. If they're
We're not
complaining
asking,
about, if they're complaining about violations, it would have been it's separate enforcement.
Your Honor.
Those are not relevant.
What I'm looking at is the answer of the motion for enforcement, and it looks like counsel pled the affirmative defense as unclean hands being one of those.
Yes, Your Honor. But the defense that they're raising is to separate violations or dates. They're not unclean hands to the actual dates that we've pleaded.
So, Judge, no, they're stating that this order is being violated. I have pled unclean hands. I get to plead all affirmative defenses, and when they put it on there that their client's trying to come in here and say that it's been violated, I'm allowed to show her honor. She is violating as well. I'm not asking for relief. I'm trying to show my affirmative defense from my case.
But they're not specific to these dates, Your Honor, and that's my issue.
It does not matter. I'm showing the same kind of conduct that she is providing. Her honor is allowed to consider this is a temporary order that they're trying to enforce, saying it's unambiguous, and that she's doing the exact same thing.
The court will overrule the objection and give it its appropriate weight.
Ma'am, I just want to briefly go through this. Exhibit R4. You see here on March 3rd, Mr. Gonzalez asking to talk to your daughter with no response from you.
Yeah, yes, I see it.
On March 9th, I have her iPad. I want to drop it off. Hello. 2 outgoing calls. You see how he's asking for time to speak with your daughter on March 9th and you don't respond.
I see that, yes.
On March 10th, do you see how he asked and you don't respond?
Yes.
You just told her honor through your time that you tried to call and he doesn't do it, and that you do give him his calls, but you were not being honest, correct? Yes or no?
That was
Yes or
early
no,
in the
ma'am?
year, and since then I've been letting him have his telephone calls.
Okay, so you're claiming you violated earlier, but not anymore. Is that what you're stating?
Pretty much.
Okay. April 8th, 2025. 2 missed calls, nothing from you, correct?
Correct.
May 10th, 2 missed calls, no response from you, correct?
Correct.
April 13th, missed call, no response from you, correct?
Correct.
June 29th, missed call, can I talk to Sophia? No response from you, correct?
Correct.
August 8th, getting into later in the year. Can I talk to Sophia? Outgoing call. No response from you, correct? Correct?
On
Is
the
that
app messages, yes.
on the app messages? Yes. How about August 7th? Same thing. Missed calls. Hello, I want to talk to Sophia. No response from you, correct?
Correct.
September 2025. Hello, I want to speak to Sophia. A missed call from earlier. No response from you, correct?
Correct.
November 28th. 3 times he calls between 5 and 8. No response from you, correct?
Correct. I do want to add at this time, Sophia had her phone. So,
So if Sophia has her phone, that's a way to communicate with her, correct?
correct.
That would be you making her available, correct?
Yes.
So same thing goes for the child involved with debt. Sophia had her phone that you got her. She was made available, correct?
No.
Okay. All righty. December 14th. Same thing. Father trying to call. Is Sophia busy? Where's Sophia? No response from you, correct?
Correct.
Do you recall December 18th or December 18th, 2025, you keeping the child from him during his Thursday possession?
No.
You don't recall taking your child to your graduation and College Station that time period?
Objection relevance.
Again, I'm showing unclean hands, Judge. They're asking for 9 hours of makeup possession, wherein this mom has violated my client's time and is somehow asking for makeup time when she's specifically kept the child away from him on his right of possession.
No.
Hold on 1 second, ma'am. I'm reading your question back, counsel.
Mm-hmm.
Sustain as to relevance, and counsel, you ran out of time. Attorney Hines, you have 2 minutes and 13 seconds left.
Thank you, Your Honor. Ms. Nina, very briefly, when we read this order on temporary orders, what did you understand subsection A to mean about telephone access?
That we both have to help make Sophia available on each of our times for a 20-minute call.
Judge, may I screen share again, Your Honor?
Sure. Mr. Cantu, I'm getting ready to stop your screen. Okay, there you go.
Oh, sorry, Judge.
Okay.
Just very briefly, let me reshare. Okay, Ms. Nina, right here in subpart A, can you see what I'm sharing? Okay. Subpart A, the parent who's with the child shall make the child available by telephone. What did you mean by, what did you understand that to mean?
By telephone, basically either a telephone call or a video call.
Okay. Did you think that meant text message?
No.
Okay. And then did dad attempt phone calls daily when Sophia was with you?
Yes.
Did you understand these calls were to be daily?
To be what, sorry?
To be daily.
Daily, yes.
And did father understand that as well?
Yes.
Judge, and that's speculation.
Sustain.
Was Mr. Gonzalez attempting to call you every day when Sophia was in your possession?
Objection is to leading.
Yes.
Sustain, don't lead.
Miss Nino, how often did father call you when Sophia was with you for a phone call?
Every day.
Okay. Pass this witness, Your Honor, and I call myself on fees.
Okay, go ahead. You have 39 seconds.
Thank you, Judge. We previously tendered mothers 25 and 26. My name is Cassie Hines. I'm an attorney licensed in the state of Texas and the state of Oklahoma. I've been licensed for 5 years. The fees in this case were reasonable and necessary. The evidence has shown there have been 29 separate violations of father not returning or making the child available for telephonic calls. The order is specific. It says by telephone. Judge, we filed this enforcement. We began work in January. These violations went back all the way to last summer. We have tendered my fees. As I stated, Mother's 25, Mother's 26 is the summary. My CV, the billable statements beginning January until this hearing, Your Honor, have all been tendered. These were reasonable and necessary. I practice primarily in the area of family law. My current rate in this case is $3.75 per hour.
Counsel, you ran out of time.
Thank you, Your Honor.
You're welcome. So you rest, obviously.
Yes, Judge.
Okay.
Judge,
Go
I,
ahead, counsel.
I apologize, Judge, and only because this is an enforcement. If we're allowed to just have a brief closing, I just would like to point out the things that are what I'm saying about the enforceability, if I may.
Oh, well, it's not necessary. It's not necessary because the court is going to have a challenge enforcing the order because the order itself is ambiguous, and it is not specific enough for contempt. This order really needs to be clarified for both parties, not just for the mother. It needs to be clarified for dad as well. Considering that dates are contained in the actual motion, it may not be a bad idea to put actual days of the week that they contact the child between a certain period. But as it is right now, the court can't enforce it. It's not enforceable as it is written. And the court can't modify it or clarify it either any further without actually making changes to the underlying order itself.
Okay, Judge.
So the motion for enforcement, the request and the motion for enforcement are denied.
Thank you, Judge.
Thank you all. You're excused. Have a good day. And Ms. Nino, I don't know if I told you, but happy belated Mother's Day.
Thank you, Judge.
You're welcome.
Hey, Judge.
You're welcome.
Happy Mother's Day.
Thank you.
One more thing. I
Yes.
seen you on YouTube.
Oh, well, nice to meet you.
Yeah. Too.
Are we excused, Your Honor? Thank you.
Yes, you're excused. Yes.
Yeah.
Okay. Did you see anyone else check in on that last case besides the state? I didn't either. State, and this case that I'm admitting now, this is the last case. So I don't know what happened. I don't know.
Outside.
Yeah, and I haven't even received any exhibits or anything. Did the state submit any exhibits?
No, I think I was told that they have in a conference maybe about.
Okay, an exhibit conference. Yeah, I don't see anything. Let me just double check one more place, just to make sure I didn't miss anything.
Is this Grant?
This is Ariana, the one she's here on. Grant is on the screen. I just admitted them into the Zoom. Let me see. I don't see anything. I see a dismissal hearing that took place on May 1st, but I don't see that the case was actually dismissed.
Or any exhibits? I don't see any exhibits.
Yeah, and they did do their exhibit conference on the 4th. So it wasn't dismissed. I don't know. But you're excused. Yeah.
Do you believe the case is just gonna sit there until somebody makes a move, or is there?
More than likely, we'll get another dismissal date put on it and get it sent out to your office so you'll know. Okay. You're welcome. Good to see you.
802.
Yes, 802. All right. Good morning. Well, good afternoon now.
Good afternoon, Judge.
Afternoon. So let me see. I think I have some exhibits from you all. I have mother's. Hold on. I have to sign back into my account. 1 second. It just knocked me out. I have, you want me to forward them to you? Okay. Oops. Okay, Julie, I just forwarded both to you. Okay, so the exhibits that I have mother's exhibits 1, 2, 3, 4, and 7. And then for father's exhibits, I have 1 through 11.
Yes, that's correct, Judge.
Okay. And I just forwarded those to my court reporter. So give her a minute to get those.
Mhm.
And the order, excuse me, the motion for enforcement that is set before the court today is the one from April 22nd of 2026. Or I'm sorry, April 30th, the amended one.
Yes, Judge, that is correct. Mhm.
Okay. All right, thank you. Wait a second. By her. Do we have competing enforcements, one for child support and one for possession and access and the geo restriction?
Judge, to my understanding, only our enforcement is set before the court today.
Okay. And that is Mr. Grant's.
Yes, that is correct, Judge.
Okay. And counsel, where is your client?
My client is on Zoom here,
No,
Kenneth
I
Grant.
see him. Oh, I'm
Yes.
sorry. Miss Johnson is, okay, I just admitted her. I had to scroll up to find her.
You did. Sorry, it was confusing. We both represent Mr. Grant.
Okay. So Miss Johnson is representing herself.
Yes.
Got
Yes,
it.
Judge.
Got it. Good afternoon, Miss Johnson.
Good afternoon.
Happy belated Mother's Day to you.
Thank you.
You're welcome. Sorry, I didn't see, I had to scroll up to actually admit you. So we haven't moved forward on anything just yet. I'm sorry. Okay, so the first amended motion for enforcement, possession, and access geo restriction. All right, got it. So father's exhibits 1 through. Joey, did the email come through?
Yes, sir. Oh,
Okay.
And Your Honor, I
Yes.
do not have representation, and I have been informed that I'm entitled to a court-appointed lawyer because he's requesting jail time.
Well, if depending on your testimony, wait a minute, hold on. Did you have an attorney?
I did,
Okay.
and I was not able to keep paying her financially, so she withdrew from the case.
All right.
And then, Judge, if you need any clarification as to what we're seeking, I believe our proposed order was approved this morning. We had previously filed it on Friday, and what we are seeking is a suspension of commitment for contempt.
All right. Hold on 1 second. Let me make sure I write these numbers down right. 2, 3, 4, and 7. So mother's exhibits 1, 2, 3, 4, and 7. And then father's exhibits 1 through 11. That's what
Yes,
you
Judge.
have, right, Julie?
yes, sir.
Okay. Okay. All right. Ma'am, are you alleging that today that you're indigent?
Yes.
Okay. All right, so counsel, this is what we'll do. We'll have a rights hearing for Ms. Johnson. And based on the outcome of that, we'll proceed. Ms. Johnson, are you familiar with a rights hearing?
No. No,
Okay.
not-
Okay, so a rights hearing takes place before a motion for enforcement hearing when the person that is requesting the motion for enforcement, well, they're requesting contempt. It takes place before that to determine if you're indigent. If it is determined that you are indeed indigent, then by law, I have to appoint a court-appointed attorney to you. However, if it's determined that you're not indigent, you have two options. You can either proceed representing yourself, or you can hire your own attorney again.
Okay.
All right. Both sides ready to proceed?
Yes, Judge.
Ms. Johnson, you ready?
Yes.
Joy, you ready? All right. We're on the record in cause number DF2202738. Counsels, will you please announce for the record?
Yes, my name is Mitchell Ryan Rogers, and I'm joined with a counsel, Bathsheba Tabakman.
All right. And Ms. Johnson, will you please announce for the record?
I'm Tabitha Johnson.
Okay. Would both of you please raise your right hands? Do you both swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, I do.
Thank you. We are here today set on the motion for enforcement filed by and through Mr. Kenneth Grant. It's the first amended motion for enforcement of possession and access and geographic restriction that has been on file with the court since April 30th of 2026. Prior to going on the record, there were some exhibits that were pre-admitted. They will be admitted at this time. So father's exhibits 1 through 11 are admitted, as well as mother's exhibits 1, 2, 3, 4, and 7. Mother at this time is requesting to have a rights hearing, and we explain what the purpose of the rights hearing is. So Attorney Rogers, will you be asking Ms. Johnson any questions, or will it be co-counsel?
It will be co-counsel.
Okay. Counsel, you may proceed.
Thank you, Your Honor. Ms. Johnson, is it correct that you're asking for the court to appoint you an attorney today?
That is correct.
And that's based on your allegation that you are currently indigent?
That's correct.
Are you currently employed?
I have not started working yet.
Is it, so no, you're not employed at this time?
Right.
And when's the last time you were employed?
In March.
Of 2026?
Yes.
And how are you employed at that time?
I was employed through Walmart
And where was that Walmart located?
in Mississippi.
And how much were you making with your employment at Walmart?
At 14.
Is that hourly?
Yes.
And how many hours per week were you working?
About 14. It was
You were working?
Yes.
Oh, part-time. Was that your only?
Hours a week.
Was that your only source of income?
Yes.
Do you receive any help from family?
No, I don't.
And do you have any savings at this time?
I do not.
Are you able to work full-time?
Yes.
And why was it that you were employed in Mississippi?
Because I had to have a job to feed my child.
When did you move to Mississippi?
In October of 2025.
And before you moved to Mississippi, how were you employed?
I was employed through Delta Airlines.
And what did you do for Delta Airlines?
Customer service.
And how much were you making at your job doing
$21
customer
an
service?
hour.
And were you full-time?
Yes.
Ms. Johnson, allow her to finish the question because my court reporter is writing down everything that you all are saying, okay?
Yes, ma'am.
Okay.
And just for purposes of the record, do I need to restate the last question?
No.
Okay, thank you, Judge. And Ms. Johnson, why is it that you're currently not employed full-time?
Because my position doesn't begin until May 18th. And I will be working full-time.
And what position is that?
It would be office manager.
And where is that position located?
It is in Dallas, off of Polk.
And you said that will be full-time?
It will be.
Here at this time, I pass the witness.
All right. Ms. Johnson, are you moving back to Dallas?
We are already back in Dallas. That happened back in March. So I had to, when I came back in March, I quit my job and we have fully been back since March 22nd.
Okay. All right. Thank you for clearing that up because I didn't understand it at first. Was something else I was getting ready to ask you. Who are you living with right now?
My sister.
Do you pay any bills with her?
Yes, I do.
What bills do you pay?
Well, I just give her $100 a week so that way for food and everything.
How were you able to give her $100 a week?
My child support.
From Mr. Grant?
Yes.
Okay. All right. Is there anything further, counsel?
Not for me, Your Honor.
All right. So this is what we're going to do. Based on Ms. Johnson's testimony today, she would be considered indigent. The court is going to appoint you an attorney from the public defender's office. Okay, Ms. Johnson?
Yes, ma'am.
Now, whatever the reset date is, the public defender will already be on notice of it because I'm going to prepare an order and send it over to them so they will know the exact reset date, okay?
Okay, thank you.
You're welcome. In the meantime, not that it's required, I just always encourage parties to do so. Try to, see if any informal settlement or whatever you all can have. I just think it works best that way because Ms. Johnson, although they are requesting a suspended sentence, they're still seeking contempt, okay?
Yes, ma'am.
All right. So everyone get your calendars out. Go ahead. Did anybody say something?
No, I was just kind of nodding to getting my calendar out. Apologies, Judge.
Oh, okay. No worries. I was looking down. I just wanted to make sure I didn't miss anyone. So the first available that the court has is July the 6th. Then it goes to the 13th, the 20th, and the 27th.
Any of those days would be fine for me.
Okay. They're all on Mondays.
I need them.
Thank you, Judge. Can we do the 13th?
The 13th? Sure.
Okay.
Now on the 13th, let me tell you which times are available. There's a 10:30 and an 11 o'clock available.
Either time works for us.
Either time works, Judge.
All right. Let's see. Whichever one the computer allows me to do, that's where we'll land at. Okay. And will this be on Zoom or in person?
Either one works for our office, Your Honor, whatever is more convenient for the court.
Bless you. If there is no objection, it'll be set for Zoom.
No objection, Judge.
Okay. All right. So, Ms. Johnson, I am resetting this matter until Monday, July 13, 2026 at 11 o'clock a.m. That will be via Zoom, the same Zoom code that you used today, 688-044-0164. Your failure to appear on that day may result in a capious warrant being issued for your arrest. Do you have any questions about those instructions?
No, ma'am.
Okay, so once the order is received by you, you will be instructed to make sure that you follow up with the attorney that will be appointed to you through the public defender's office, and just make sure that any directives that they give you, you comply with those, okay?
Yes, ma'am.
All right, is there anything further for the record?
Yes, can we
No.
just, so are they gonna reach out to me about the court? The attorney? Or do I need to reach out?
You'll reach out to them. So they'll receive an order, and in that order that they'll receive, you'll also receive it too, and it'll have their contact information in there for you.
Okay, perfect.
Okay. Thank you all. You're excused.
Thank you.
Thank you, Judge.
Thank you. You're welcome.